What is the historical debate about software patenting? Imagine trying to protect a recipe or a dance move with a patent. Now, think about software, which is made up of lines of code and algorithms. The question is, should these digital creations be eligible for patent protection? This has been a hot topic for decades. Back in the 1960s and 1970s, the United States Patent and Trademark Office was hesitant to grant patents for software. They saw software as just abstract ideas or mental processes, not something you could patent. They believed software was too intangible and not tied to a physical device, so it didn't qualify. During that time, there was also a big debate about whether software should be protected by copyright law instead. Copyrights cover the code itself, but patents are about protecting inventions. It wasn't until the year 1980 that the United States passed the Computer Software Copyright Act, which made software copyrightable. But the question of software patents was still unresolved. The first software patent in the United States was granted in 1960 to Martin A. Getz. It was an early sign that software could be patented, but the legal rules were still unclear. In the early 1970s, the Supreme Court ruled that algorithms alone could not be patented. This limited what could be protected. As the years went by, courts and the Patent Office started to see software differently. In the 1980s and 90s, they began to accept that software could be part of a patentable invention if it was linked to specific technological improvements or produced real technological results. For example, if software turned a regular computer into a new machine or process, it could be patented. This shift was important because it recognized that software innovation was vital for technological progress. But even now, debates continue. Critics say that software patents can be too broad, making it hard for others to innovate. They worry that patents can block new ideas, especially in emerging fields like artificial intelligence. Supporters argue that patents encourage companies to invest in developing new software. They believe patents help protect genuine technological advances. Today, the debate is ongoing in courts and legislatures. The challenge is to find a balance, protecting true innovations without giving out overly broad patents that hinder progress. As artificial intelligence and machine learning become more complex, the question of what software can be patented gets even trickier. Lawmakers and courts are trying to keep up, making sure patents promote innovation without creating monopolies over basic ideas or algorithms. So, the history of software patenting is really about how the law has struggled to keep pace with fast-changing technology. It started with skepticism and strict limits, then moved toward acceptance when software showed clear technological benefits. But the debate still rages because of concerns over fairness, innovation, and the future of digital progress.